Good afternoon, everyone, and thank you for joining our third Thursday webinar. My name is Susan McComas, and I work in the marketing department here at Synergy. I'm going to be on the line fielding all of your questions. If you have any questions, I just want to point out the control panel. It should be in the right of your screen, or it might be minimized. But you can click on that, and you'll see a box that says questions. If you type your questions into the questions field and hit submit, that'll send it to me, and we will address your questions via email after the presentation today. Today's topic is ethical issues at settlement and closing cases compliantly, and it's going to be presented by our CEO, Jason Lazarus. And with that, I would like to turn it over to Jason.
Thanks, Susan. The topic today is a complex one because I'm sure if you've noticed anything of late, it is that the issues that can arise at settlement are becoming more and more complicated when you have someone that's got either catastrophic injuries or significant disability related to the injuries they suffered in an accident. So I am going to try and, in an hour, go through as much as possible about the different issues that are coming up in cases to make sure that you've got the basics in terms of understanding what issues can arise and then knowing how to ultimately close the case compliantly without running afoul of any of your responsibilities to the client in terms of explaining the legal issues before they walk out the door. So in terms of what I'm going to cover today, I'm going to talk about disability planning, focusing on needs-based benefits and special needs trusts and Medicare set-asides and Medicare compliance. Briefly, we'll talk about the Affordable Care Act and settlement trusts. The end of the presentation will focus on some of the ethical issues at settlement, malpractice issues that can arise with structured settlements, and then finally finishing with an overview of qualified settlement funds, which is a quite useful tool for certain cases where all of these issues can crop up and cause delays in terms of getting resolution of the case. So focusing on those that are disabled, the reason why it's so important to plan for clients that are disabled is because they are going to be receiving some type of public benefits if they have a qualifying disability, and that can provide them with a lifetime of financial support and medical care in addition to the monies recovered for the injuries that they suffered. And by utilizing a plan, that plan can supplement what they need for the rest of their life, but also a proper plan is going to have in place a system of advocacy for that client to make sure that they are protected and taken care of, and provide the client with a knowledgeable and long-term team to manage the settlement monies and manage their government assistance eligibility. So it's really important for clients that are disabled that they get counseling regarding what can be done to protect their benefits. But not every disabled client is going to require special planning. It's only those that are so severely disabled that they meet the definition of disability for eligibility for these types of public benefit programs, and they're currently qualified for programs such as SSDI and Medicaid, or they're currently eligible for Medicare, or they're eligible for both, which is dual eligibility, which is Medicare and Medicaid eligibility. So before we get into talking about some of the needs-based benefits, it's good to distinguish between the types of benefits and understand the differences between them and also the connections between them. So the needs-based public benefits are SSI and Medicaid, and most states there's a connection between SSI and Medicaid, and I'll talk about that in a moment. The entitlement benefits are SSDI and Medicare. So you have to be able to distinguish in your practice when you're working with clients between SSI and SSDI. They're both programs that are administered by the Social Security Administration, but one is needs-based, which is SSI, and one is an entitlement, which is SSD. And so being able to distinguish between the two is important, because if a client's on SSI, then you know Medicaid is most likely going to be involved. If a client has qualified for SSD, then they're going to have Medicare entitlement at some point in the future. Also, you probably will come across Section 8 housing benefits and also veteran benefits, which can be income and asset sensitive. But so focusing on the needs-based benefits first, for clients that become disabled but have not worked enough quarters and paid into the system, they can qualify for SSI, which is basically just a monthly cash payment for those that are 65 or older, blind, or disabled. The current maximums are $733 a month for someone that's single, $1,100 a month if they're married. For the SSI program, there is an asset cap, which is $2,000 if they're single, $3,000 if they're married, and an income cap. So both apply, and in order to become eligible, you have to be below the income and asset cap. And then Medicaid is the basic health care coverage for the indigent. And as I alluded to before, there is a connection between SSI and Medicaid. In nearly all states, if you qualify for SSI, you automatically get Medicaid. In Florida, that's the case, my home state, and as I said, many others. There's a few states that you will have to apply separately if you get SSI, but you will automatically be granted if you qualify. And then there's a few states that do have some more restrictions. But generally speaking, if a client's on SSI, then they're likely going to have Medicaid in place as well. So if a client is on Medicaid and or SSI is disabled, that's a situation where you want to consider a special needs trust. And the reason for that is because if assets are held in the name of a person with a disability, they would become ineligible for SSI and Medicaid because, for example, if you give a client a $50,000 settlement, in the month they get it, it's income, so they're over the income cap in that month. If it's not spent down by the first day of the next month, it's an available resource. So it's really important to understand that even giving a client $10,000 could be cause for them to lose their eligibility because they will be over that income cap, and if it's not spent down by the next month, they'll be over the asset cap. And one of the things that comes up frequently is the thought process, well, the SSI payment's small, we can forego that. It's just not that big of a deal. But the problem is that if they are qualifying for Medicaid by virtue of being an SSI recipient, they're going to lose their Medicaid at the same time, and so they're losing their health care coverage. They can apply independently for Medicaid, but as soon as they become ineligible for SSI, they're going to immediately become ineligible for Medicaid at the same time. So in order to prevent that from happening, one of the solutions is to create a special needs trust. And there's a couple different kinds that can be utilized in the context of a personal injury settlement. The first is a D4A or standalone special needs trust, which can be created for anyone that's disabled that is under the age of 65. The next is a D4C pooled trust that can be created for someone that's disabled but of any age. Both a D4A and D4C are called first-party trusts, which means they're created with the injury victim's assets. The other type of trust that can come up is a third-party special needs trust, which is created with assets other than those of the injury victim. And where that can arise is if the community did a fundraiser for an injury victim, those funds would go into a third-party special needs trust. Or it could be a situation where mom and dad now have a disabled child. They are doing their estate planning, and when they do it, they create a third-party testamentary trust that their assets flow into for the benefit of the minor child when they pass, so that the minor child doesn't lose eligibility. So the advantages of creating this type of trust is that it keeps their public benefit eligibility intact for those needs-based benefit programs. It gives them a professional trustee to manage their assets and manage their eligibility, because for the most part, you don't want parents or family members acting as trustee because they cannot successfully navigate the complex rules for eligibility that apply for SSI and Medicaid recipients. Even lawyers have a hard time reading the regulations that govern eligibility for the SSI program and Medicaid. So typically speaking, in the context of personal injury cases, it's set up with a corporate fiduciary or a not-for-profit trustee. The trust typically can avoid guardianships and the annual reporting requirements for minors and incompetents. And then these types of trusts can pay for everything except food and shelter. Food and shelter is prohibited by the SSI regulations. If a client is not on SSI, then the trust can pay for food and shelter, but most times, because there's that connection between SSI and Medicaid, the clients are on SSI and that food and shelter exemption applies. The disadvantage of creating this type of trust is that the client doesn't have unrestricted use of the funds. The trust is a sole benefit trust, which means it can only be used to benefit the trust beneficiary, which would be the injury victim. At death, Medicaid has a payback requirement. So this is in the federal law. In order to have a special needs trust whose assets are excluded for purposes of qualifying, there has to be this payback provision. So it is something that you can't get around. The only exception to it is third-party trusts, which are not the injury victim's assets, are exempt from a payback. So having a trust like this in place does add an extra layer of complexity for the client, and the trust is irrevocable. It can't be a revocable trust. So once it's done, it's done. Two issues to be aware of before moving on. One is deeming, and what deeming is for example, if you have a husband and wife who have a personal injury case going on, the wife was the one that was injured, husband has a consortium claim. If the wife's assets are put into a special needs trust, but the husband gets his consortium claim paid in cash, his money is deemed to his wife. Same thing with minor children. So say you have a catastrophic injury to a minor child, mom and dad have a consortium claim, minor child's assets are put into a special needs trust, mom and dad get a couple $100,000 for their consortium claim. You just disqualified that minor child, even though you set up an SNT for the minor child, because mom and dad's assets are deemed to the child. So frequently in those scenarios, really, it's best if mom and dad forego their consortium claim, or you can have a situation where, say, the court orders mom and dad to have a consortium claim, mom and dad go out and buy a house, which is an exempt asset, which was what I was going to talk about next. That is a solution. There are ways around it, but you just have to address it and plan properly. So exempt assets are something that can be an alternative to establishing a trust in certain cases. For example, there are two major assets that are exempt. The first is a house and the second is a car. So if a client was, say, getting $25,000 and wanted to go out and buy a car, they could take receipt of the money and buy the car within the same calendar month they get it, and it won't interfere with their Medicaid eligibility because the car is exempt as long as they only have one car. Same thing with a house, only one house. So they can go out and spend the money down within the same calendar month and not interfere with their Medicaid eligibility. But if they're on SSI, the money they get in that 1 month will be income to them, so it will interfere with SSI eligibility. But if they spend it down within the same calendar month, it's only going to impact 1 month of SSI payments, and they'll resume at their regular rate after they have had the reduction in the 1 month. So there are ways around it, and you have to contemplate those before deciding whether a trust is the right avenue to go down or a spend down plan on exempt assets. I wanted to talk a little bit about pooled trusts because pooled trusts are a type of special needs trust. That's the D4C that I mentioned with the previous slide, that are very economical and a great solution for really any size settlement. And the reason for that is because it's managed by a not-for-profit trustee under federal law. Typically, their annual fees are much lower. There's no minimum trust deposit. Most corporate fiduciaries want $500,000 or $1 million in a special needs trust to manage it, whereas you could put 10 grand into a pooled special needs trust. But you could also put $1 million in because it's going to be economical and the investment options are going to be such that there's no downside to the client. These trusts, as I said, are established and managed by a not-for-profit. Each person that's part of the trust has their own separate account, but the funds are pooled together for investment purposes. So you have a master trust that people are joining, and so each person that joins has their own separate sub-account, but it can only be established for someone that's disabled within the Social Security definition of disability. And then at death, the funds are either retained by the not-for-profit or used to reimburse the state Medicaid agency under that payback. So the pooled trust is somewhat different from standalone special needs trusts under D4A because there's no age restriction. So someone over the age of 65 can create a pooled trust, whereas they can't create a standalone. And there's a master trust instead of an individually crafted trust. So I wanted to go through some of the frequently asked questions that come up because if you're counseling a client, you really need to know some of the basics about utilizing special needs trusts. And really these apply whether it's a pooled special needs trust or a standalone. It's anyone that's disabled and needs to preserve Medicaid or SSI that can join. They don't have to have a determination from Social Security of disability, but they have to fall within the parameters of being disabled within the Social Security definition. With a pooled trust, all they need to do is sign a joinder agreement, which is a legal document, but it's a little bit different from what happens with a standalone because it's not an individually drafted trust. And then in terms of the types of assets that can be placed in the trust, it's pretty much anything, any type of assets they have, typically in the context of personal injury case, it's the personal injury settlement. So as I said, there's no minimum amount with the pooled trust, and they can add funds from, say, subsequent settlements at any point in the future. And when they want money, they simply submit a distribution request. Typically, it's going to be required to be in writing. And then the investment gains on the trust assets are taxable. And that's why frequently these types of trusts are funded partially with a tax-free structured settlement, which minimizes the trustee fees to some extent and also exempts the buildup from being taxable since the assets invested inside the trust are taxable. And in terms of utilization of the funds, really the primary things are that the trust can only provide for the sole benefit of the trust beneficiary, and the trust beneficiary cannot get cash. Other than that, it's pretty broad-based. It's not limited to medical. It's anything really that improves that person's quality of life. It could be vacations, experiences, travel, things that are not being provided for by government assistance. So going to the movies, case management, family members accompanying that person on a trip, supplemental nursing care, basically really nearly anything and everything, things around the house, furniture, clothing. So it's pretty broad-based. One thing that has come to the forefront more recently are ABLE accounts. And those are sort of an alternative to a special needs trust, or it can be used in tandem with a special needs trust. It can only be created for someone that's disabled prior to age 26. There is a maximum yearly contribution, which is $14,000, but it can't hold more than $100,000 total if a client is on SSI. And these are like 529s. Each state has their own ABLE account, or most states. I don't know if every state has them yet, but because they're relatively new. The nice part about these is that they can be used to pay for food and shelter expenses. It does have to have a Medicaid payback provision, but so a pooled special needs trust can be set up to fund an ABLE account, and also a structured settlement can be used for that same purpose. So there's some unique planning that can be done for clients if they fall within the parameters of being able to utilize an ABLE account, which is the primary thing is being disabled prior to age 26. So now moving on from needs-based benefits to Medicare, Medicare compliance has become a much greater issue because of some things that have been going on within the CMS agency, which is charged with administering the Medicare program. And I'll talk about that in a moment. First, I want to talk about just some of the basics. So SSDI and Medicare, neither are income or asset sensitive. They're entitlements. They're funded by the taxes we all pay to the government out of our wages. If a client has enough quarters paid into the system and becomes disabled, they can get SSDI, which is different from SSI in that you have to have enough quarters paid into the system. And then if you become disabled, then ultimately you'll get Medicare entitlement 30 months thereafter. And what that 30 months total is there's a 6-month elimination period before you get your first SSD check, and then 24 months thereafter you become eligible for Medicare. And Medicare coverage is made up of several different parts. Part A and Part B are traditional Medicare, which is your hospital and medical insurance, and Part D is your prescription drug coverage. Part D, unlike Part A and Part B, is administered by a private insurance company that provides the coverages based on Medicare program parameters and is funded by Medicare dollars, but there are premiums to be paid. Part C is Medicare Advantage plans, which someone can elect out of A and B and into Part C. Part C will pay for all the things that A and B pays for and will incorporate Part D coverage as well. And for someone that's dual eligible, it can even incorporate Medicaid coverages into it. So it's pretty comprehensive, but the Part C plans have become very aggressive about their subrogation rights. So you have to be careful about screening your clients to make sure that you know whether they're on Part A and Part B or whether they've elected into Part C, because that can impact your subrogation issues, which is a bit beyond what I'm going to talk about today, but I wanted to mention that because it's an important issue to keep in mind. So the Medicare Secondary Payer Act is the basis for why we're talking about this in the first place. And really all the Medicare Secondary Payer Act says is that Medicare should be secondary to all forms of insurance, including workers' compensation, liability, and no-fault insurance. So the agency, Medicare, interprets the Medicare Secondary Repair Act as comprising two different obligations or issues or considerations for personal injury settlements. One is payments prior to the date of settlement, which are the conditional payments, and those payable after the date of settlement, which are the futures, which are the conundrum of Medicare set-asides, which I'll talk about in a little bit. So I'm going to talk real briefly about some subrogation issues, which I alluded to previously. So first, I'll talk about conditional payments, and then I'll talk about the Medicare Advantage plans, just to give you a brief overview. But so when you're resolving a case for a Medicare beneficiary, there's a couple different options for resolving the Medicare conditional payment. One is just to pay the amount. The second is to appeal whatever determination they've made with a final demand. And the last is doing a compromise and waiver. And there's three different ways to go about requesting a compromise or waiver. But what we recommend to clients is that they go this compromise and waiver route, because they pay the final demand, which stops the interest meter from running, versus an appeal, which keeps the interest meter running. As long as the final demand has not been paid, an appeal does not toll the interest. So the way to fight these things is via compromise and waiver. And believe it or not, there are ways to get a financial hardship waiver, for example, in seven-figure settlements. One of the largest refunds that we've been able to get from Medicare, which is the net result of a compromise or waiver, which is you get a refund back from Medicare of the amount that was paid. We got a complete refund on a seven-figure case for a grandmother that was the victim of a home invasion where her daughter was killed and she was shot multiple times. But she had a seven-figure recovery, but we were able to get Medicare to issue a complete refund, which I think was around $173,000. But believe it or not, Medicare actually cuts checks back if you're successful in fighting it through a compromise or waiver. And since 2013, I think now we're close to $3 million recovered for Medicare beneficiaries by pursuing the compromise and waiver after payment of final demand. So the Medicare Advantage plan liens have become a much greater issue of late, because the Medicare Advantage plans are entitled under the Medicare conditional payment statutes and the regulations to the same real rights as Medicare itself, which includes bringing a private cause of action for double the amount that should have been paid back to the Advantage plan. And those actions can be brought against the personal injury attorneys handling the underlying case, which we worked with some clients who that's exactly what happened. They got sued for the lien amount, which was $191,000 times two. Ultimately, the case was settled during the course of litigation, which was before the Western Heritage case, which is an 11th Circuit case, which basically said that in that case they had sued the defendant insurer, said the defendant insurer was responsible for double the amount of lien payable to the Medicare Advantage plan, even though they had already paid the client for that amount that the client, the injury victim, was supposed to reimburse the Advantage plan. And these are really what I would call hidden liens, because if you call Medicare and say, hey, I've got this client, they've got Medicare, they're going to tell you that there is no lien if it's an Advantage plan, because the Advantage plans are administered by private insurance companies. So Medicare does not know about those payments. They can only tell you if A and B have paid. They can't tell you if Part C has paid anything. So you got to be really careful now with subrogation-related issues as it relates to these Advantage plans. So moving from payments prior to settlement, now I got to talk about futures, which I think makes most lawyers' eyes roll into the back of their heads, and I understand why. But here's a few key takeaways from this part of the presentation. You only have to worry about this issue if you have a current Medicare beneficiary or arguably somebody with a reasonable expectation of becoming one within 30 months. I say arguably because that second category, those with a reasonable expectation, that comes from workers' comp cases, and it's never been asserted that it should be, that standard should be used in liability cases. But as we sit here today, there's currently no regulations, statutes, or cases that require an MSA yet. And I'll talk about the current landscape because it's important to understand kind of where things are going. But as we sit here today, in my opinion, it's analogous to cases involving Medicaid and SSI recipients, which is you've got to explain to them, legally speaking, that they've got the ability under federal law to create a special needs trust which keeps their eligibility intact. With Medicare, it's no different. The client needs to understand very clearly that if they settle their case with the defendant and they get money for future medicals from that defendant, it is possible that Medicare could deny their injury-related care. Is it highly likely? Probably not, but they need to understand there is that risk, because what you don't want is you don't want a client to get denied care and then come back to you and say, you didn't advise me about this, this is a legal issue, you've committed legal malpractice, which I think if you don't explain it to the client, you have committed legal malpractice. There's just no way to get around that fact, because there is this risk, and I'll explain why the risk is so great in a moment. But these Medicare set-asides can be used offensively to set a floor on medical damages in the right case. So there is some silver lining in the right case for this particular issue. But the only reason that this has come to the forefront is because of mandatory insurer reporting, which was created by Section 111 of the MMSEA. And MMSEA created the mandatory insurer reporting, which means that defendants have to report settlements based on the requirements of this law. And they have to report settlements involving Medicare beneficiaries. And this reporting is comprehensive. It's a data dump that's done electronically by the defendants. It includes the ICD codes, and it effectively allows Medicare to identify every settlement, or nearly every settlement, involving a Medicare beneficiary. And a practice point about these reporting requirements is that defendants have a habit of reporting either incorrect ICD codes or improper dates of accident, and those can cause a nightmare and a headache. The reporting of the wrong ICD codes is an issue that can cause the client to get a denial. And what can happen is, say you've got an automobile accident where the client suffered neck and back injuries. The defendant throughout litigation takes the position that the neck is pre-existing, ultimately settles the case and says, we're not paying any dollars for the neck, we're only paying for the back. But they go to report the settlement to Medicare and they report the ICD codes for both the neck and the back. Well, your client could then get denied care for the neck-related injuries because those ICD codes were reported. So one of the ways to avoid that issue is either to have a written agreement about what ICD codes will be reported, or put it even in the release what will be reported, so that you know what's going to be reported, because if something incorrect is reported or pre-existing conditions are reported, that can be a headache and a nightmare for your client to clean up. Same thing with date of accident, because if the wrong date of accident is reported, say you report the correct date of accident when you're trying to resolve the conditional payment, you get it all resolved, then the defendant at settlement reports a different date of accident, you could get a new final demand from Medicare, and that is a nightmare to resolve. So you got to be careful about these issues. And really the reason why this reporting becomes so critical is because it does give Medicare a heads up on settlements that are being had with Medicare beneficiaries, and that can lead to a denial of care. And if there is a denial of care, there are 5 levels that you're going through before you get to see the inside of a federal district court. And that can take a lot of time, which means if there's been a denial, the client would go without appropriate care that's covered by Medicare until that is resolved in a federal court. Now, all a Medicare set-aside is monies that are set aside for injury-related medical expenses that are normally covered by Medicare. So it's a carve-out or a deductible that the client self-pays until it's exhausted. So it's completely different from a special needs trust. With a special needs trust, Medicaid will pay as primary. With a Medicare set-aside, the set-aside becomes primary until it's exhausted. And the way a Medicare set-aside is calculated is based upon the injury-related medical expenses normally covered by Medicare, the annual prescription expenses covered by Part D, times remaining life expectancy. That would be the Medicare set-aside allocation. And rated ages are utilized in the context of Medicare set-asides. And rated ages are utilized in the world of structured settlement annuities to price out annuities based on a reduced life expectancy. So Medicare takes as evidence of reduced life expectancy the rated ages. The rated ages result in a smaller MSA because life expectancy is reduced. And if you look at the way a set-aside is calculated, it's calculated over remaining life expectancy. So if that's reduced, it lowers the number. But also because annuities are used to fund MSAs typically, there's about a 20 to 30% typical cost savings by funding a set-aside with an annuity. So this has been where there's been a lot of chatter and news and a lot of things being said throughout the plaintiff's bar and the defense bar, and a lot of it is confusion and misunderstanding. So hopefully by the time I get done explaining this, you'll have a clearer picture, although it's unfortunately without codification, there's nothing ironclad and definitive, but you'll have a better understanding of the lay of the land. So the really only thing that addresses liability Medicare set-asides is a regional handout that was done by Sally Stalcup in May of 2011. And basically it lays out a general obligation to protect the Medicare trust fund when future medicals are funded, whether it is a liability settlement or workers' comp settlement. It says in the memo there is no distinction between either. It is important because it talks about the defense obligations, which really are only to notify that future medicals are being funded, which obligates the plaintiff to protect the Medicare trust fund, and then report the settlement under mandatory insurer reporting. So if you have a recalcitrant defendant who says, we got to put Medicare set-aside language in the release, we got to do this, we got to do that, we got to do Medicare set-aside, you can use that handout to show them, hey, Medicare is saying, no, that's not what has to be done. Because really this is a plaintiff issue. If the plaintiff doesn't do anything, the plaintiff suffers the potential consequence of having Medicare deny care. The next memorandum came out from Medicare itself, the regional office, the headquarter office in Baltimore, which basically says that a Medicare set-aside is not necessary in a liability settlement if the treating doctor certifies in writing that there'll be no future Medicare covered expenses related to the injuries suffered. Obviously, that's not very helpful because most cases there is going to be future medical care, but in those certain cases where you can get the treating doctor to write such a letter. It is helpful, but it's also instructive in that Medicare is saying that there is this need to protect the Medicare trust fund if you don't get this certification. Then starting in 2012, Medicare began the regulatory process to create regulations and guidelines for liability Medicare set-asides. So they did this initiation of the process, which was an AMPRM, which basically was an announced policy, and they went through a comment period, and then they did a notice of proposed rulemaking in 2014, which was subsequently withdrawn in October of 2014. So since that time, up until recently, there really was very little going on. As a result of that, there's been some cases that are of note that I wanted to mention briefly. Marine Terminals, which is a 2011 Federal District Court opinion, dealt with the issue of the parties agreed to a CMS-approved liability Medicare set-aside as a condition of settlement, but Medicare, their regional offices, have a policy of not reviewing these in certain jurisdictions, and they couldn't get CMS to review and approve a set-aside, so they went to Federal District Court and asked the court to do it, which the court did, but it's instructive in that you don't ever want to, even if you're going to do a set-aside, agree to a CMS-approved set-aside, because that could set up an impossible contingency in your settlement. The next case, the Benoit case, deals with the issue of what you do if future medicals are $1 million, but your total recovery is policy limits of $100,000. Obviously, you can't set aside $1 million if you're only recovering $100,000. So there has to be a way of reducing the set aside to take into account the fact that liability issues or policy limits precluded a full recovery. And that's what the Benoit case dealt with, and it came up with a formula, which is something that we've advocated in our MSP compliance program, which is basically sort of like an equitable distribution argument, looking at what the total damages are compared to what the client actually recovered. So if the client's only recovering 10% of their full damages and their set-aside's $100,000, they should only set aside $10,000 because the rest of the monies are for damages other than for future medicals. The next case is a state case, Sterrett v. Klebart. In that case, there were competing claims, consortium claims, and other elements of damages that effectively made it such that the plaintiff's future medicals were not funded at all. And that's an argument for why a set-aside shouldn't be done, because if there is no funding of future medicals, there should not be a set-aside, because one of the prerequisites to needing a set-aside is funding of future medicals. And that's one of the things the Stalcop handout talked about too, was that lawyers have to review and analyze whether settlements involve the funding of future medicals. The last case I included because it was widely distributed in 2015 as standing for the proposition that Medicare set-asides are not necessary in liability settlements, but really what it stands for is what I've said from the outset on this issue, which is that there's, and this is a direct quote from the case, there's no federal law or CMS regulation requires the creation of an MSA and personal injury settlements to cover potential future medical expenses. But the fact that there is no law or regulation doesn't mean that CMS could not deny care, or Medicare could not deny care, even if it's wrongly, and even if there's no legal basis for it. If your client does suffer the denial, they're going to not be happy, and they're going to be coming back to you and asking why they weren't advised of the risk. So that's some background of the way things were. But starting in last year, AAJ saw that things were kind of moving towards a renewed interest in MSP compliance by CMS. And then in February, there was an announcement by Medicare that was sent to all of Medicare's contractors saying that medical claims submitted post-resolution of a liability settlement should be denied if they should be paid from a liability Medicare set-aside. It is a bit confusing because it talks about cases that don't have an MSA being processed under the current MSP claims processing instructions. We don't really know what all that means. We're expecting clarification before October 1 of this year, although I'm not entirely confident that we will actually get clarification because Medicare is notoriously bad for clarifying what needs to be done. Even in workers' comp, where these set-asides have been routine for a long time, there are no regulations or statutes. It's all regulated by policy memorandums that Medicare can change at their whim. So unfortunately, we're left in that same scenario, and we'll have to see in the end how it shakes out. So in the interim, best practices are you've got to make sure you're identifying Medicare beneficiaries within your practice, and that's anyone that's about to turn 65, those who have SSDI eligibility, those in end-stage renal disease, those with ALS, or a child that's disabled before age 22 with a deceased parent or disabled parent drawing Social Security. So you want to start early at intake, and you want to take charge of this process, not the other side. And you've got to identify those Medicare beneficiaries, confirm disability eligibility with Social Security, get copies of all their insurance and government assistance cards. That's particularly important with the Medicare Advantage plans to make sure that you know exactly what that client is receiving benefits under. And really to decide whether there's anything to be done in terms of MSP compliance, there's a couple of questions. Is the plaintiff eligible for Medicare benefits? Will there be future accident-related care? And does the case fund future medicals? If you get a yes to all those, then a set-aside analysis should be considered, not necessarily a set-aside, but analyzing what, if anything, should be set aside. If it's no to all those, then a simple either you yourself do a letter to the file, or you have a third-party company like us do a no MSA evaluation letter, something to document why nothing was done. So again, the summary of best practices: develop a process to identify cases with Medicare beneficiaries. If they are a Medicare beneficiary and future medicals are funded, educate the client on the risks of not setting aside. If they decide they want to set something aside, select the appropriate solution, and then document your file, which is easily summed up by an acronym CAD, which I think at the outset you want to make sure you have experts that can help guide you through this process, unless you feel confident in educating the clients on your own. Ultimately advising the client about the MSP and then documenting your file. So briefly, when cases are done with a Medicare set-aside, a pooled Medicare set-aside trust can be established to keep their Medicare set-aside properly administered. Because of the complicated nature of administration and turning Medicare eligibility on and off if you have temporary exhaustion in a given year, this type of solution is one, low cost, and two, going to be in the best interest of the client. And because of most set-aside administration solutions being custodial arrangements, this is unique because it's a trust, which gives the client a document that goes on in perpetuity and protection from creditors and judgments and whatnot. So the last part about planning for those with disabilities is the Affordable Care Act and changes in planning. Obviously, we know with the ACA, it is possible that's going to go away, but the ACA did away with pre-existing conditions. It does provide subsidized premiums for private health insurance that's based off of modified adjusted gross income. And importantly, structured settlements aren't equatable to taxable income, which is what triggers some of these tax subsidies. So in planning for clients that are going to use the ACA, you've got to keep that in mind. It did impact and expand Medicaid, which is state by state. For example, Florida didn't expand Medicaid, but it has had an effect on special needs planning, and that is that there are cases where SSI and Medicaid probably should be foregone and instead utilize the ACA. But in those cases, typically a trust is drafted for the client that allows them to fall back to Medicaid if the Affordable Care Act is gone or is no longer affordable. So it's basically a trust that has special needs provisions that allow for the client to qualify for Medicaid down the line if they need it. And for some clients, those that are not on needs-based benefits, pooled settlement trusts are a really unique solution, particularly for minors or incompetents that can avoid a guardianship but provide liquidity and flexibility to the injury victim. These trusts are irrevocable spendthrifts, but it can be used for health, welfare, maintenance, and support, and it can be set up to mimic a structured settlement with minors with future lump sum distributions. And importantly, too, these trusts are drafted in such a way that they have the flexibility to protect public assistance eligibility if the client ever needs it down the line. So it's a good way to protect the assets and have professional management of their monies, and also provide enough taxable income to trigger tax subsidies. Because excuse me, remember, for the Affordable Care Act, those are going to be triggered by taxable income. So with that, I'm going to move on to the last topic and probably move through this pretty quickly, which are the ethical issues at settlement. So when you resolve a case for someone that is disabled, the laws that I've talked about already, which is 1396 PD4, which are special needs trusts, the Medicare Secondary Payer Act, that needs to be explained to the client so they understand the impact. Also, 104A2 of the Internal Revenue Code needs to be explained to the client so they understand that they have two different options when they resolve a case. One is to take a lump sum and invest it on their own, which can trigger tax consequences, and also, if they're on public assistance, destroy their eligibility, or do periodic payments with an annuity and pair that with trusts that protect their assets, but also give them a tax-free investment vehicle. One thing that you have to be aware of is constructive receipt and making sure you don't trigger that. That is a tax doctrine, and once you take the monies into your trust account, constructive receipt is triggered, and that can impair the client's options, and it is a malpractice concern potentially that is problematic, and I'll explain why in a moment. So, you know, I think there is a couple of fundamental questions that hopefully throughout this presentation you've kind of been asking yourself is, you know, what are my obligations with regard to advising clients about public benefits, the techniques to protect eligibility, the now talking about the obligation to advise clients regarding financial options. I think in most instances, personal injury lawyers, rightfully so, are focused on the value of the case and obtaining the best financial recovery for the client. But substance over form can be devastating for the client if the proper planning is not done, and there's typically a mismanagement of the recovery and loss of public benefits if they don't get the counseling. And I think if you read the model rules, and I'm not going to go through these, but if you read them all together, I think in the end you will see that there is some sort of obligation. The Grillo case is a good example of a case where lawyers were sued based on the fact that they didn't set up a special needs trust, they didn't utilize a qualifying structured settlement. So basically, they caused this client to become ineligible for Medicaid and SSI and lost the tax benefits of a structure. And obviously, as you can see, there was a pretty large settlement against the plaintiff attorney, and ironically, even a larger settlement against the guardian ad litem. So if you're ever acting as a guardian ad litem, be careful about what you're signing off on. And if you look at some of the studies that have been done on legal malpractice claims, this one's becoming more aged, but is probably still pretty right on. It was done by the ABA, but there's a very large percentage of malpractice claims that are related to personal injury cases, and advice and settlement negotiation made up over 23% of the claims overall, and those were tied for first in terms of highest claims by type of activity in this study. So failing to give advice like this, because there are some very easily quantifiable damages, the loss of public assistance can be quantified, the loss of the protection of settlement proceeds, the loss of a tax break is quantifiable. It definitely leads to a greater concern that if you don't do these things, you potentially have some malpractice risk and exposure. But in my opinion, these laws, all the things that we've been talking about that impact settlement, have to be explained to the client, because if you don't, there's no way the client can make an informed decision, and possibly they lose the opportunity to exercise these options that are available under the law. And if you don't address these issues with the client before they walk out the door, who will? And the threshold is really quite low, because if it's a client that's on Medicaid, it could be as little as $2,000 if they're single. So you have to really think about these issues. Lastly, structured settlements are an area that's ripe with potential malpractice risks if the client doesn't have independent representation in that transaction. And the key areas of concern are triggering constructive receipt. As I said, once you've taken constructive receipt, it can trigger loss of public benefits and no possibility to ever do a structured settlement. There's really only two ways to avoid constructive receipt. Either the defendant holds on to the funds and funds the structured settlement directly, and or the trust, or does a qualified settlement fund, and I'll talk about that as the last part of the settlement. And there are ways through the way a structured settlement is done that can create more protection for the client. For example, the client at no cost can become a secured creditor in the event that there was a failure of the life insurance company, which is unlikely, highly unlikely, but there's no reason not to do it. It's just some extra paperwork. And also diversification, spreading structured settlement premium amongst several companies. Could be 3 companies, could be 5 companies. You just have to look at it and analyze it. And then also looking at the companies, strength of companies that are being utilized. Are they A+ or A++ companies through AM Best, which is the most typical rating service, but also looking at S&P ratings. You've got to know the risk you're taking. And then pricing becomes very important, and pricing is based upon 2 different things. Rated ages highly impacts pricing, and then the actual pricing scheme of the different companies. Certain companies are better at certain payment streams, and knowing that and putting together a combination of companies can create an arbitrage that you can take advantage of. So if you take a look at this comparison, you'll see what kind of a drastic difference a rated age can make. And in this example, the defendants did not get the rated age of 64 because it wasn't a company that they had on their approved list. So that's really important to understand, that there are cases where the defendant could offer something that's not in the best interest of the client, simply because the company is not on their approved list. And obviously this made a dramatic difference. And ultimately in this case, the life insurance company that was utilized was on the approved list, but matched the benefits that were out there in the best company in the marketplace, which was the rated age of 64. So really what you need is a cost comparison across different companies, something like what you see on your screen, which shows you the differential in cost going from a very high of $228,000 to a low of $202,000. So obviously that's a pretty $26,000 difference in cost on a small annuity is pretty dramatic. One of the things that is often overlooked are estate tax considerations. And with the estate tax being where it is, the exclusion, it's not applicable on many cases, but on larger cases, this can become a large issue. And if it's not dealt with at the time of settlement, it's too late when the person dies because there is no liquidity if it's not dealt with on the front end. There has to be an estate planning commutation rider, which is free of charge, but just provides a lump sum payout at death to pay estate taxes. And sometimes this is preferable for a lot of other good reasons too. A client wants their heirs to have other investment options after they die. If there's Medicaid estate payback issues, you need the liquidity, or Medicare set-asides, the funding parameters are no longer necessary post-death, so the heirs don't really want or need those types of restrictions. So hopefully through that brief discussion, you can see there's a lot of different issues that can arise, and it's good to understand those and make sure you employ experts who can advise you about all those different issues. So the last topic I'm going to hit on is something that most trial lawyers probably have never heard of or dealt with, which is a qualified settlement fund, or QSF. And what that is it's a trust that can be created pursuant to Treasury regulations, and it acts as a holding tank for settlement proceeds, and it allows you to settle with a defendant for cash, but it doesn't trigger constructive receipt. The money is considered in this trust while planning is being done for complicated issues. Say there's multiple plaintiffs and they have to allocate between, some want to structure, some don't. Some are Medicare eligible, some are not. One's on Medicaid, they need a special needs trust. So there's a lot of different reasons why a QSF can be very handy. Typically it's in catastrophic cases or cases with multiple claimants or issues that just need time for resolution. The drawback is it does require court approval, and there's some additional expense associated. In order to establish a QSF, it just has to be established pursuant to an order of a court of law. It doesn't even have to be a court with jurisdiction over the underlying case. It has to be established to resolve or satisfy one or more claims arising out of a tort in this context, and then it's a trust under applicable state law. The way it works is between the plaintiff and defendant, it's just like settling the case for a cash payment. You execute a cash release. The settlement proceeds are payable to the QSF. A court is petitioned to establish the QSF, and once the order is obtained, the defendant can fund the qualified settlement fund, and the funds sit in the QSF without violating constructive receipt until, say, there's allocation decisions that need to be made, liens taken care of, an S&T or MSA is created, or an amount to be structured in the plan is decided upon. And that can even be the attorneys deciding to defer taxation of their legal fees. That's another reason why oftentimes these are utilized. And then the QSF terminates once all the funds have been dispersed. So when and why to implement one? If you've got multiple claimants with allocation issues amongst them, if you've got a case involving multiple layers of coverage and you want to aggregate the settlement money, say you're settling with one defendant now for $100,000, but there's $1 million policy that you're going after, and possibly an excess policy of $5 million, say, and you really don't want to do planning with just $100,000 because ultimately you know there's going to be more money. you can set up a QSF and have all the settlement monies ultimately flow into that. If you've got complicated lien resolution issues, public benefit planning issues, structured settlements are contemplated for the client or the attorney, all the above. Those are some of the reasons why you might want to utilize those. So I hit a ton of information in a relatively short period of time. On the screen is my contact information. If you would like a copy of the PowerPoint, you can email myself or Susan and request a copy of the presentation. One of the things that we do very frequently is free consultations with the client and you about these issues. So if you come across cases that have some of these complicated issues, you can consult with us and we will give you a roadmap for making sure the client ultimately is protected. I want to thank each and every one of you for taking the time out of your day to attend the presentation today, and hopefully you found it useful.
Thanks everyone for joining us, and thank you, Jason. And just like Jason said, I will send everyone an email with a copy of today's presentation, PowerPoint slides, and also the recording. We have our third Thursday webinars every month on the third Thursday, so we hope you guys will join us again. Thanks. Have a great day.